Hello, and thank you for tuning in. Are you a hotel manager, GM, or might you happen to play one of the various important roles in the hotel and lodging industry? Maybe you're a tourist or frequent traveler. Either way, this video is for you. Whether a guest or a member of hotel staff, I'll be providing you with some important information that'll benefit you and perhaps make you think a bit more next time you're traveling or on the clock. Today, we'll be taking a look at the hospitality industry in terms of hotel liability. Specifically, we'll take a look at the liability hotels have for guest property. But first, let's break this down historically. Let me ask you though, are you familiar with English common law?
Common law just means the case law that has developed over the years. And the basic common law duty when it comes to innkeepers is that the innkeeper has an obligation to maintain their premises in a reasonably safe condition and to prevent against foreseeable dangers.
Now, our legal expert there helped introduce one of our points for discussion today. And if you haven't heard the term innkeeper before, this is just an archaic term for someone who runs an inn. So a 19th and 20th century innkeeper would be the equivalent of today's hotel manager. And our legal expert is right. Innkeepers back then and hotels today have a general obligation to maintain their properties in a safe condition and avoid foreseeable dangers. Of course, one can argue that loss or damage to personal property as a guest can be considered a foreseeable danger. Now, according to the Washington State Hospitality Manual, believe it or not, under English common law, innkeepers were deemed fully responsible for the value of any property belonging to a guest. This was established by a ruling made by the Supreme Court of Appeals of West Virginia in 1896. As much as common law benefits guests more than innkeepers, we see evidence of this beginning to change in the 20th century. In 1909, the Washington State Supreme Court approved exceptions to an innkeeper's common law liability. Then, in 1915, legislation was enacted to further limit the liability innkeepers had for guest property. A statute in the Revised Code of Washington represents one of the first times we hear talk of a hotel safe, for the safekeeping of money and other valuable items, of course. For many people nowadays, we don't know a hotel without a safe. Go figure. So as new laws are created, we begin to see a shift in responsibility. More of this is placed on the guest as time goes on, but keep in mind, there are stipulations hotels must abide by, such as posting notices about the availability of a safe. As the hotel industry evolved, hotels and motels took things a step further. While hotel liability laws can vary from state to state, there became an option to acquire innkeeper's insurance. This type of insurance helps cover costs associated with loss or damage to guest property. In 1989, CBiz Incorporated, a financial services and business consulting firm, decided to form the CBiz Innkeepers Insurance Program. Based on an in-depth analysis of the industry, this organization felt the need to help businesses, and to date, CBiz is the largest insurer of innkeeper businesses in the United States. Now, remember when we talked about stipulations hotels must abide by to protect themselves? Well, this is a very important aspect to any legislation that has been enacted to limit hotel liability for guests' property. One of the easiest things a hotel can do is post notices in conspicuous areas requiring guests to properly lock their doors and alerting them of the existence of a hotel safe and/or an in-room safe for depositing their valuables. In a South Carolina Court of Appeals case, Ippolito versus Hospitality Management Associates and Holiday Inns Incorporated, a couple successfully sued a motel franchise due to personal property being stolen from their room. While the motel attempted to cite South Carolina's innkeeper statute, a jury found that the motel did not fully comply with the elements of this statute. Here, there was an issue of whether or not a conspicuous notice existed at the hotel, and it was ultimately found that the motel was 60% responsible for the couple's loss. This meant that the motel did not properly comply with the requirements of the state statute. This goes to show how explicit communication is key in order for hotels to properly protect themselves. Fast forward to the 21st century, the modern legal framework surrounding hotel liability for guest property has become quite specific, placing specific responsibilities on both hotels and their guests.
If you're staying in a hotel in the United States, your rights as a consumer are outlined in the terms of your hotel reservation and in your state's lodging laws.
And he's right. According to the Gale Encyclopedia of Everyday Law, nowadays, most hotels have established significant limits to their liability for guest property. If you walk into most hotels and motels, those notices about valuables, safes, guest and hotel responsibility will be posted in several conspicuous areas. Additionally, there are statutory limitations in terms of coverage for loss or damage to guest property, including dollar amount limits of what can be covered. Furthermore, there are clauses which state that liability can also be dependent on potential negligence, whether on behalf of the hotel or its guests. And according to KTNV, Channel 13 based out of Las Vegas, Nevada, this state's Innkeeper statute states that hotels are actually not liable for stolen property if guests had access to an in-room safe. So think about that for a moment. This is yet another example of how laws are strikingly different than what was discussed just a few minutes ago in this video. As you can see, there are both pros and cons to being either a hotel operator or a guest looking to stay in a hotel or similar establishment these days. Both parties have been affected in different ways by the evolution of innkeeper liability laws. The bottom line is that there seems to be much more balanced system in the hotel industry today. Hotel liability for guest property has taken the initial burden placed almost solely on hotels and shared it with guests, who do take some sort of risk, no matter how big or small, when entrusting a hotel security. However, the hospitality industry lives and breathes customer service, and so many of today's establishments, especially larger hotel chains, may go the extra mile to ensure the happiness of its guests and to encourage return service. I hope you enjoyed this video. Take care and travel safely.